Losing a loved one is undeniably one of life's most difficult and emotional experiences. In the midst of navigating profound grief and trying to heal, families are often faced with a complex and daunting legal process known as probate. Probate is the legal procedure of settling an estate after someone passes away. It can feel overwhelming, but understanding the basics can help ease the burden. Please remember, this guide is for informational purposes only and is not a substitute for professional legal advice. Let us walk through the essentials together.
Have you ever wondered what exactly happens to a person's estate after they pass away? Enter probate. Probate is a formal, court-supervised legal process designed to validate a deceased person's will and oversee the proper distribution of their assets. It is the legal bridge between someone's passing and the transfer of their wealth.
But why is this process so essential? First, probate serves to officially validate the deceased's last will and testament, ensuring it was properly executed and legally binding. Without it, there is no legal authority to act. Furthermore, the court steps in to protect the estate's assets during the transition period, preventing unauthorized individuals from taking control. Probate isn't just about giving things away. It's also about settling accounts. The process ensures that all legitimate debts and final taxes are paid off before anything goes to the heirs. Once the slate is wiped clean, the remaining assets are accurately distributed to the rightful beneficiaries. Finally, if any family conflicts arise over the estate, the probate court provides a structured environment to resolve these disputes fairly under the law. The probate journey begins with filing the will and petitioning the court. In many states, this is a time-sensitive requirement. For example, under Florida law, whoever has possession of the original will must file it with the local circuit court clerk within 10 days of learning about the passing. Alongside the will, a formal petition is submitted to open the probate case. This petition officially asks the court to validate the will and grant authority to begin settling the estate. Once the court reviews the petition and validates the will, the next major step is officially appointing an executor or administrator. The judge signs the necessary orders, issuing a powerful legal document known as letters testamentary, or letters of administration if there is no will. This document is the golden ticket for the executor. It grants them the legal authority to act on behalf of the estate, allowing them to access bank accounts, speak with creditors, and manage the deceased assets. Once probate opens, the executor must notify all interested parties. This means mailing formal notices to heirs, beneficiaries, and known creditors. In most jurisdictions, they must also publish a legal notice in a local newspaper. This gives unknown creditors a specific window of time to step forward and make a claim against the estate. Next, the executor takes on the meticulous task of inventorying the assets. They must locate and document everything owned by the deceased at the time of death, from financial accounts and investment portfolios to physical belongings like jewelry and furniture. Every item must be carefully cataloged. But knowing what exists is only half the task. The executor must also determine its value. Professional appraisers are often brought in to evaluate real estate, antiques, or unique collections. All this data is compiled into a comprehensive inventory, featuring the date of death values for every asset, providing a clear financial snapshot of the entire estate. With the court's approval secured, the executor steps into their primary role, managing the estate's assets. This begins by opening an official estate bank account to consolidate funds. From here, they must carefully maintain and protect physical assets, ensuring properties are kept up and investments are monitored. But before any inheritance is passed down, the estate's obligations must be settled. The executor uses the estate account to pay off legitimate debts, final income taxes, and administrative expenses. Creditors are notified, and funds are carefully distributed to clear the financial slate. Once the debts are cleared and the mandatory waiting period has finally passed, the moment everyone anticipates arrives, distributing the remaining assets. Following the exact instructions of the will or state law, the executor transfers funds, property deeds, and personal items to the rightful beneficiaries. The very final milestone is closing the estate.
The executor submits a comprehensive final accounting to the probate court, proving that every penny has been handled correctly. Once approved, a judge issues a final decree, discharging the executor and officially completing the probate journey.
Probate looks entirely different depending on whether you leave a valid will or not. When you pass away with a will, known as dying testate, your written instructions guide the process. But if you pass away without a will, known as dying intestate, state laws take over, deciding exactly how your assets are distributed.
So, how long does the probate process actually take? There is no one-size-fits-all answer. A simple estate might close in as little as 3 months. A standard process typically takes about a year, while complex estates can easily drag on for 2 years or more. Several factors dictate this timeline. The sheer complexity of your assets, heated family disputes over the inheritance, and even local court backlogs can severely delay the proceedings, keeping your loved ones waiting. How much does probate really cost? Total expenses typically range from 3 to 8% of an estate's value. This breakdown includes court fees, executor compensation, attorney fees, and professional appraisal fees, which can quickly drain thousands of dollars. Fortunately, you can bypass these costs with a few alternatives. First, a living trust acts like a secure digital vault, transferring assets instantly to heirs. Second, joint ownership ensures property automatically passes to a surviving owner without court involvement. Third, beneficiary designations on life insurance or bank accounts direct funds straight to your heirs, completely outside of probate. Finally, if the estate is modest, your family might use small estate procedures, relying on a simplified small estate affidavit. Even with careful planning, probate can sometimes lead to family disagreements. Common disputes often involve will contests, where the validity of the document is challenged, or intense disagreements over the valuation and distribution of specific assets. These conflicts can quickly drain estate funds and fracture relationships. To navigate this process, an executor is appointed to manage the estate. Their responsibilities are vast and require meticulous attention to detail. The executor must identify and secure all assets, carefully manage the deceased's finances during the transition, and ensure all legitimate debts and taxes are paid before any inheritance is distributed. Because the legal requirements are complex and the emotional stakes are high, seeking professional legal assistance is highly recommended. An experienced probate attorney provides crucial guidance, ensures compliance with state laws, and offers steady representation to help resolve disputes and close the estate smoothly. Thank you so much for joining me today. Dealing with probate can feel overwhelming, but remember the key takeaways. Understand the probate process, explore your alternatives, and always seek professional guidance. If you found this video helpful, please hit that like button, subscribe to our channel, and leave a comment below with any questions you might have. For more detailed resources and expert help, head over to probateus.com. Remember, while we hope this video provided clarity, always consult with a qualified attorney for your specific situation. Wishing you and your family peace of mind moving forward.